Welcome to the Bar Exam Toolbox podcast. Today we're talking about contract defenses as part of our Listen and Learn series. Your Bar Exam Toolbox hosts are Alison Monahan and Lee Burgess. That's me. We're here to demystify the bar exam experience so you can study effectively, stay sane, and hopefully pass and move on with your life. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Alison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review on your favorite listening app and check out our sister podcast, the Law School Toolbox podcast. If you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on barexamtoolbox.com, and we'd love to hear from you. And with that, let's get started. Welcome back. In today's podcast, we're going to discuss contracts. More specifically, we're going to discuss contract defenses, including mistake, fraud, misrepresentation, and non-disclosure. Although some of these concepts might be unfamiliar, we'll explain all of the terminology and rules that you need to know. To review these rules and illustrate these concepts, we'll also go over two hypotheticals adopted from the California bar exam. So, we're going to do something different today and start with our first hypothetical, adopted from the February 2018 California bar exam. To view the full hypothetical in question, you can check out the link in the resources page at the end of the transcript. Also, you can look in the show notes. Oh, and feel free to take notes as we dive in. Okay, on to the question. Austin recently sold a warehouse to Beverly. The warehouse roof is made of a synthetic material called top tile. During negotiations, Beverly asked if the roof was in good condition, and Austin replied, "I've never had a problem with it." In fact, the manufacturer of top tile notified Austin last year that the warehouse roof would soon develop leaks. The valid written contract to sell the warehouse specified that the property was being sold as is with no warranties as to the condition of the structure. After Beverly bought the warehouse, the roof immediately started leaking. Beverly then sued Austin for rescission of the warehouse sale contract on the basis of misrepresentation and non-disclosure. Will Beverly be able to raise any defenses to contract formation and rescind the contract with Austin? Discuss. So, to begin, I want to emphasize how we structure a contracts essay and think through issue spotting. In a contracts essay question, we always start with an analysis of the governing law. We have to decipher whether UCC Article 2 or the common law applies. The governing law matters because it dictates some of the rules we must use. While Article 2 of the Uniform Commercial Code, the UCC for short, applies for all contracts for the sale of goods, the common law governs service contracts. After we determine the governing law, we need to make sure a contract was formed. This requires us to go through an analysis of offer, acceptance, and consideration. Note, though, that sometimes our essay question will tell us off the bat that the contract was formed. When that's the case, we don't need to do an offer, acceptance, and consideration analysis. We can simply quickly mention that we have a contract. Now, that leads us to our third step in issue spotting a contracts essay, and the focus of our podcast today, assessing defenses to contract formation. This practice question brings up several legally significant facts. In particular, we know that Austin fudged over what he knew about the roof, and that he didn't tell Beverly about the leaks. These facts raise the issues of misrepresentation and non-disclosure. So let's take a look at our rules for each. A fraudulent misrepresentation occurs when one party, 1, knowingly, 2, makes a false representation, 3, of a fact, and 4, the other party reasonably relies on the misrepresentation to their detriment. A contract induced by a fraudulent misrepresentation is voidable, may be rescinded by the injured party. The contract defense of non-disclosure, on the other hand, requires that the plaintiff show that defendant 1 did not disclose a material fact, that 2 formed the basic assumption of the agreement, and that 3, the plaintiff reasonably relied on his statement. Okay, so with those rules behind us, let's dive into our question. As we mentioned at the outset, we want to follow a systematic approach to answering our contracts questions. The first is always to identify the governing law. Here, the common law applies because we aren't dealing with a sale of goods, which would trigger the UCC and have a real estate transaction. Next, let's make sure we have a contract. In this instance, we're in one of our lucky situations where the question comes right out and tells us we have a valid written contract. Because of that, we don't have to go through our contract formation issues of offer, acceptance, and consideration. But I'd probably still write down that the question said there was a written contract just so the grader knows that you recognized it. So let's move on to our next step. Do we have any defenses to contract formation that Beverly can invoke? Well, as we said, our facts trigger two primary defenses: misrepresentation and non-disclosure. During negotiations, Beverly specifically asked if the roof was in good condition, and Austin responded with the fact that he had never had a problem with it. He made this statement knowing that Top Tile had notified him a year earlier that the roof would soon develop leaks. This brings us to our last element that we must prove in our misrepresentation claim, whether Betty reasonably relied on the misrepresentation. Austin will argue that Beverly did not rely on his misrepresentation and that Beverly did not make it clear in her comments to Austin that the condition of the roof was a material fact of the contract. He'll also point to the clause that the property is sold as is to show that she didn't rely on his statement. Well, on the other hand, Beverly will contend that Austin's misrepresentation as to the condition of the roof certainly formed the basis of the bargain. A leaky roof on a giant warehouse structure would be very expensive to fix, and if she had known, she may not have purchased the property. An astute examinee should argue both sides of this issue, but still come to a conclusion. Because the facts don't indicate that Beverly relied on the statement when purchasing the product, a court will likely reject Beverly's fraudulent misrepresentation defense to contract formation unless other facts showing her reliance arise. Next, let's look at Beverly's possible non-disclosure claim. Remember that with non-disclosure, we're focused on what Austin should have said. Here, while Austin misstated the roof's condition, he also failed to disclose the true condition of the roof. However, we run into a similar problem that we did with our misrepresentation claim. Beverly must successfully argue that the roof's condition was a material fact that formed the basis of the agreement. Austin will argue that Beverly didn't make it known, either through her conduct or her words, that the roof was critical to her entering the contract. In addition, he'll point into the as-is clause in the contract. Thus, a court will likely find for Austin on the issue of non-disclosure as well, unless other facts arise. Okay, great work with this question. Now, to practice these concepts again, let's take a look at another hypothetical. The next hypothetical is adopted from the October 2020 bar exam. Daniel's house is for sale. In his living room are two valuable original paintings by artists, one of the California coastline and the other of a field of Golden State wildflowers. Daniel recently refused an offer from a museum to purchase the paintings for $10,000 each. Pam went to Daniel's house hoping to buy it before she left on a business trip. As Pam, Daniel, and his real estate broker, Bill, inspected the house, Pam noticed the paintings in the living room, commenting that they were beautiful and seemed designed to fit the house. Pam then offered $400,000 for the house and another $50,000 if the sale included the two paintings. Daniel agreed and asked Bill to draft a contract for the sale of the house and the two paintings for $450,000. Bill promised to have the contract ready before Pam left town the next day. Bill drafted a written contract, which Daniel signed even though he noticed that Bill had mistakenly omitted from the sale the painting of the California coastline. Daniel met Pam at the train station as her train was about to depart. Daniel gave the contract to Pam, telling her, "This is what we agreed to, and I've already signed it." Pam's train started to move, so she quickly signed the contract without reading it and jumped on board the train. When Pam returned from her trip, she was horrified to find that the California coastline painting was not in the house. She immediately telephoned Daniel to ask about the painting, but he told her, "That's what the contract we signed provides," and hung up. 6 months after Pam moved into the house, she noticed a local newspaper advertisement that Daniel was offering to sell the artist's painting of the California coastline to the highest bidder at an auction 2 weeks later. What defenses to contract formation can Pam raise? Discuss. Well, to answer this question, let's go over a few additional rules and terms. We need to take a look at the defense of mistake. There are 2 types of mistake: mutual mistake and unilateral mistake. Mutual mistake is what it sounds like, a mistake made by both parties. Mutual mistake occurs when we have 3 elements present. 1, both parties are mistaken as to a basic assumption on which the contract is made. 2, the mistake is material to the contract. And 3, the person asserting the mistake did not bear the risk of the mistake. Bearing the risk for the mistake could occur by agreement or by a party treating their limited knowledge as sufficient. With a unilateral mistake, there are 4 critical elements to keep in mind. A unilateral mistake is 1, a mistake made by one party; 2, that is unknown to the other party; 3, concerning a basic assumption; 4, that has a material effect. To be material, the mistake must be about an issue that would impact whether the parties would agree to enter into the contract in the first instance. Importantly, a unilateral mistake is generally not a valid defense to formation. But if one party knew or had a reason to believe that the other party was mistaken, or 2, the mistake would make enforcement of the contract unconscionable, then the contract is voided by the mistaken party. Okay, with those rules in our rearview mirror, let's tackle our question. First, as we mentioned before, we always have to identify the governing law before jumping into a question. Here, like in the previous question, we have a real estate contract that will be governed by the common law. Because the prompt doesn't specifically tell us that we have a valid contract, you could earn extra points here by quickly addressing offer, acceptance, and consideration. As we're focused on contract defenses here, though, we won't go into detail on that here. So let's check out the possible defenses that Pam can raise. In particular, let's see if Pam could successfully raise a claim for unilateral mistake. Here, Pam definitely made a mistake. She thought that the contract included the unique California paintings, but the contract, in fact, did not. The mistake, moreover, was material. Pam made clear that she thought the paintings were beautiful and were a perfect fit for the design of the home. She even offered additional money, a whopping $50,000, for the sale of the home to include the paintings. When she found out that they wouldn't be included, she was horrified. The mistake, therefore, was material to the contract. Next, for Pam to be able to void the contract, she has to show that Daniel knew or had reason to believe that she was mistaken. Here, Daniel knew that the paintings were important and part of the bargain, and that it was meant to be reflected in the contract. Instead, he noticed the drafting mistake and still presented to Pam that everything was correct in the contract. This got her to quickly sign the contract. Because Daniel took advantage of Pam's unilateral mistake, knowing that she was mistaken, Pam can successfully assert the defense of unilateral mistake. Let's take a look at mutual mistake briefly next. Here, we know that mutual mistake requires both parties to be mistaken. Because only Pam and not Dan was mistaken, there is no defense of mutual mistake. Finally, let's see if Pam can successfully raise the defense of misrepresentation. Here, while the California coastline painting being omitted from the contract was originally accidental, Daniel later discovered that fact. Knowing that the painting had been omitted from the contract, Daniel knowingly and falsely represented that nothing had changed in the contract. Pam, relying on that representation, signed the contract. As a result, Pam can likely maintain a successful contract defense for misrepresentation. And with that, we're out of time. Hopefully you found these examples to be helpful reminders of how to tackle contracts defenses questions. If you're studying for the bar right now, I would definitely encourage you to practice these 2 California essay questions on your own, or you can use tools like the Brainy Barbank tool to look up California Bar or UBE questions that also focus on contracts. I also want to take a second to remind you to check out our blog at barexamtoolbox.com, which is full of useful tips to help you prepare and stay sane as you study for the bar exam. You can find information on our website about our courses, tools, and one-on-one tutoring programs to support you as you study for the UBE or California Bar Exam. If you enjoyed this episode of the Bar Exam Toolbox podcast, please take a moment to leave a review or rating on your favorite listening app. We'd really appreciate it, and be sure to subscribe so you don't miss anything. If you are in law school, you might also like to check out our popular Law School Toolbox podcast as well. If you have any questions or comments, please don't hesitate to reach out to myself or Alison at lee@barexamtoolbox.com or allison@barexamtoolbox.com, or you can always contact us via our website contact form at barexamtoolbox.com. Thanks for listening, and we'll talk soon.